Three groups and a resident are suing the town of Superior, Colorado in federal court to stop a magazine and assault weapons ban. And it could dramatically affect you, no matter where you live. Now, before we get started, make sure you're subscribed to this channel and hit the like button. Rocky Mountain Gun Owners, a Colorado group, and the National Association for Gun Rights and the National Foundation for Gun Rights, and a Superior resident, Brad Walker, filed a lawsuit against Superior, Colorado, a small town that just a few weeks ago passed an ordinance to ban standard capacity magazines of greater than 10 rounds and semi-automatic so-called assault weapons. The ordinance does a lot of things, but essentially it makes possessing firearms in the town illegal unless you can show reasons that you should be able to possess them. It completely nullifies and guts the Second Amendment itself. It's not alone either. A number of smaller towns and larger towns and counties are doing the same thing. They're being pushed by Michael Bloomberg's Every Town for Gun Control and Moms Demand Action. Now, this lawsuit might seem small against one small town, but it has broad implications for all Colorado residents, certainly all the residents of this 10th Federal Circuit, which includes Colorado, Utah, Wyoming, New Mexico, Oklahoma, and Kansas. But it also could affect gun owners across America. Now, plaintiff Brad Walker is a software engineer who lives in that town. And the attorney is Barry Arrington, a former Colorado state legislator. Now, you might remember that name if I remind you of some of the background. The Colorado legislature enacted a greater than 15-round magazine ban in 2013. And at that time, RMGO teamed up with attorney Barry Arrington to challenge it in state court. After a very long process, an expensive process, we won on some very minor points, mostly about parts kits to repair magazines. But the magazine ban was still left in place. Now, at that time, the courts used an interest balancing approach to evaluating firearms cases. Now, the Bruin decision, which was written just a few weeks ago by Justice Clarence Thomas, throws all of that out the window. Now, according to the U.S. Supreme Court, all Second Amendment cases must be evaluated based on actual text of the Second Amendment and the history and tradition of the right to keep and bear arms. Now, that decision was followed up by instruction by the court to force states to use that decision-making process. That goes for every court case that handles the Second Amendment now. Now, we aren't letting our grass grow on this Supreme Court decision. Superior gave a grace period to its residents, so nice of them, until the end of July. And so we're filing a temporary restraining order against the town to stop them. Now, we expect this to move fast, and given the U.S. Supreme Court's directive, it's going to be very difficult, if not impossible, for these kind of gross violations of the Second Amendment to withstand scrutiny. Stand by and we'll give you updates later as they happen. Now, in the description to this video, there's a link to how you can get involved in fighting for this lawsuit.